Good morning, everyone. I, on behalf of Asian Law College, would like to welcome you all to day 5th of the Faculty Development Program on Epistemological Dimensions in Research and Legal Education. I, Swati Saxena, Assistant Professor at Asian Law College, would be moderating today's session. I would like to welcome our distinguished speaker for today, Professor Dr. Nuzhat Parveen ma'am, Dr. T.N. Prasad sir, Principal, Asian Law College, Mr. Ashish Bhardwaj sir, Head, Asian Law College, and Dr. Preeti Sharma ma'am, Program Coordinator, and all the participants to the Faculty Development Program. Today we have with us a distinguished and eminent speaker, Professor Dr. Nuzhat Parveen ma'am. Ma'am is presently working as the Professor and Dean of School of Law, Bennett University. She has more than 30 years of academic experience in Jamia Millia Islamia University. She has authored various books on conflicting and contemporary legal issues like Women and the Law, Child and the Law, Women and Child-related Laws, Comparative Constitutional Law, Socio-economic Offense, etc. Ma'am has contributed and presented modules on jury metrics for the UGC e-Pathshala project at graduate and postgraduate level. She is also a member of governing bodies, academic councils, and executive councils. Ma'am has also held various academic and administrative posts like Dean, Faculty of Law, Jamia Millia Islamia, Chairperson, Law, National Council for Promotion of Urdu Language, MHRD, etc. Here, I would also like to mention that ma'am has graced various conferences, seminars, and moot courts organized by Asian Law College as a distinguished speaker and judge. So, ma'am, cherishing this association and also looking forward for the same, I would like Divyasha ma'am to present a memento as a token of appreciation from us. Thank you, ma'am. Ma'am will be speaking on the topic Law and Justice in a Globalized World. Over to you, ma'am. Thank you.
Thank you so much, and I'm so sorry for the unnecessary delay. Am I audible?
Yes, ma'am. You're perfectly audible.
Good morning, everyone. Good morning, Professor Taraknath Prasad, Principal, Asian Law College, all the faculty members, and of course, the participants. So first of all, Asian Law School have taken this task of, I think Asian Law School in collaboration with the Research and Development Cell of the university have taken this task of organizing what you call faculty development program. And I say this is a season of faculty development programs. In every school, in every law college, July, August are full of faculty. In our time, we used to call it refresher courses or orientation courses, but now they call it FDP. And I also coined one term, which when we had one, we call it continuing education, continuing legal education. So the topic which you have kept is a very dynamic topic, epistemological dimensions of research and legal education, which I understand cover every aspect of law, legal understanding, every aspect of legal knowledge, and every aspect of legal education. Further, I'll say the topic which you have assigned me is too wide a topic. I mean, what to cover or what not to cover. This can complete a full course curriculum. But anyway, I have tried my level best to point out certain aspects whereby we can understand the nature of law and justice in the present era, especially while we talk of globalization, while we talk of the world have shrunk to be a small place, the limitations, the distances, the cultures, they have been quite been each into another. There is very less gap, or the gaps have been reduced into different type of aspects. So how in the era of the justice also. So as legal students, what do we understand if we say what is law? I'll start with just simply, if I can I share the screen? Or do you want
Yes,
me
ma'am,
just
you
to
can share
speak on?
it.
However, I can continuously speak also, just for the sake of time's sake. I just would like to share some points with you. Okay, but not at every point. So when we say law, it is in our generally also law or rules. I mean, law is a set of rules which are enforceable by courts, and they regulate the government, the state, the relationship between the government and the people, the relationship between different organs of the government, and the relationship or conduct of the subject. Subject means people towards each other. So somehow law is the regulation of a society. Then similarly, justice in a society. Justice is definitely something which is the quality of being just, righteous, equitable, or morally correct, or upholding the justice of a cause. So, I mean, justice, since we are law people, we understand justice in a further liberal context and through various machineries, through various modalities, beginning from the judiciary onwards to the tribunals, to different other bodies, quasi-judicial bodies and legal bodies, and at multifaceted level through inquiries, justice is to be given. But when we talk of the concept of law and justice, because if I go on to explain those terms, it itself is a big task, and all of us are law students, we understand different, facets. But I think today's job is to talk about globalize in law and justice in the context of, globalized world, or in the context of globalization. So the term globalization, if I understand, or if I think of, talking this word globalization, it's a a very, very wide word. So here from, I just would like to Preeti share my screen to say, or to make people understand more easily, because the subject matter is a little dry. So can I mean, tell me the options where I could go to share my screen?
Ma'am, there's a screen share option.
Yes, it is coming. It is
Yes,
coming.
you can
Yeah,
share
yeah,
from
yeah.
there. I hope it is working, ma'am.
Yeah, is it visible now?
No, ma'am, you have to, there'll be option of, yes, ma'am, it is visible now.
It is visible,
Yes.
yeah. So when we talk of, however, I'll be less focusing on the slide, so please don't indulge into reading it. I've just, for the sake of, what I want to say, maybe some of you miss on. So when we say globalization, so globalization basically, it is something in the context of legal thought is very limited. And there are various reasons for it. However, today we have lots of globalization, but it's still, as compared to the other contexts. For example, if I say the reasons why it is not that easily, or it is not generally accepted term in the context of law, or it is a new paradigm of society, and it remains a little vague concept in the general discourse. What do we understand by globalization? And the debate about the globalization, it was more came into in 90s, and then too there was not a very clear consensus about the things. The reason why it is not much into the legal thought is so far that globalization in two paradigms shift. It is more towards a methodological nationalism, or globalization generally have three distinct words, that is politics, economics, and culture. Law is generally not present whenever, if you will Google even globalization, you will see the globalization in the context of politics, in the much more in the context of rather economy and culture. So law is not a term of the context of globalization in general, but we can make it slowly, gradually, I'll case that how we will say that globalization is present in the legal scenario. So sometime, or it mostly frequently, it is either completely absent, or why it is so? Because in law, we are generally have some type of doctrinal or discourse, or we have some manifest as a straightforward notion of internationalization. Somehow that affects the law. However, recently we have seen that legal theory and doctrinal research frequently use oversimplified notions of globalization. Globalization has been termed as a new world order and has resulted into the, that I already said. When we say globalization, it means the world has become a smaller place and the forces of globalization have affected all the social system. Now, all the social systems, as I already said, political, economics, and culturally, but how it has, affected legally, how it has, in the context of legally, it has affected. So how to understand, the definition or meaning of the term globalization? So when we say it is integration and democratization of the world's culture, economy, infrastructure through the transnational investment, rapid development of communication and information technology. So here again, you can see two, three words. It is culture, economy, infrastructural, transnational investment, and rapid development of communication and information technology. So accordingly, again, we can see that it is instantly screening the high level connection or networking among the nations and people with regard to the different terms. So when we say globalization, it is basically networking among nations, among people, and that too through trade, travel, and information exchange. So this is the main concern of the globalization. Now, our job is to slowly, slowly how we see the academicians or the legal fraternity have noted that globalization has an impact and how currently we understand the law. So that is how it is, slowly and gradually coming into our context. It is taking shape of how we understand, this particular thing. Legal fraternity and academia is how they are taking. So if we say according to academic community or academy or the subject matter of law and justice, understanding the subject matter of law and justice in the context of, we say that globalization. So how will we understand in the context of globalization? That is another subject which we have to understand. And according to the legal fraternity, globalization can be used as a lens to examine the way legal norms are disseminated and what are the prerogatives of the territorially bound nations. Because generally, legally, we are territorially bound. This is India. This law is applicable to the domain or the extension of this particular law or this territory, and the territory is India. We are living in a country that is the territory, and the limit of that law's extension is that territory. But today what we are trying to tell you that the law or the territorial prerogative, the territorial bound state are there, but it has become nowadays when we say globalization, then territorial limits become a little uh, 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 less salient, less relevant today's context, because globalization looks everything through the lens of the world, in the context of the world, and how we understand some of the realities which are around us and the changes that has come with them. So globalization basically is somehow takes us out of the territorial boundaries, out of those territorial limitations, or to understand the context in the context of societies across the world. And that is the real thing which is now, we have to understand. That is that globalization, rather than being a process, it serves as an analytical lens, a lens through which we can understand various socio-legal issues. How interdependent the globe has now often it is very important to think. Because in terms of, if we take the whole society, or if we take the globe as a single, society, then the importance of the nature of the laws, the nature of the judiciary, the nature of the justice system becomes very important to understand in the global context. And I'll later on come to some of the contexts that how, not today itself, because today we talk, technology is one of the reasons, isn't it? Technology have reduced the limitations, technology have reduced territorial boundaries, technology have reduced linguistic boundaries, technology have reduced, technology have brought the things very closer. So that is one of the things, but it is not the only thing. I mean, what I'm trying to tell you, that it is not the only thing. Why? When we understand, globalization in the societal context, rather in the state-centric context. When I say state-centric concept, so law is the state-centric context. The state have, because if we go to our system, in the Indian Constitution and the Indian legal system, we are a federal or quasi-federal structure. And when we say quasi-federal or federal, or somehow some features of federalism, and some are, it is unitary. So in that context, we reach to the lawmaking power of the parliament and lawmaking power of the state legislature. So whenever, it's a general understanding of the law student, a law, if it is made or, passed by the parliament, it is a law which is applicable to the whole country, isn't it? When a law is passed by the state, it is applicable to the state. And some type of things which we call our union, state, and the third thing whereby both of the bodies have the power to make the law. So in that context, again, states, union have prevalence, but the state are also bound by it. But somehow it is within our country. But the process of globalization help us to understand the things better. That does not mean a state become redundant. That does not, I mean, how and why the law transcend national boundaries and manifest transnational laws, that has become very important in today's world. But that does not mean, I'm not trying to tell you that when I say the law and justice in the globalized world, or I'll say the law transcending the national boundaries, that means that the law is only now the relevance of the state legislation or the country's legislation become less, or it is doomed. No, it is not itself. Actually, the globalization and transcending the boundaries of the law limits is a method of approaching law from a global perspective. But in that case, as I already said, the power, and in no sense the state's power or the state is doomed, or the state's law its relevance is less, because they are definitely the creator, interpreter, and enforcer of law, and that is no way it is denied. But globalization opens up the opportunities for conceptualizing the law in a wider way, in a more elaborate way. As a result, a social construct always modify according to the globalization. So one could argue that the process of socio-legal changes are made easier by the globalization. That's correct, actually. The process of socio-legal change are made much easier with the help of globalization. Now, to make it understand more clear, and not only just limiting ourselves to, that it is because of technology. Many of you may understand when we talk of globalization, when we talk of internationalization, when we talk of, understanding everything in the context of the whole world, it is because of technology. It is partly true, but it is not absolutely true. For example, I take the first example, that is constitutional transplantation. So when our constitution was written, I mean, all of us remember when we started studying constitutional law in our first year, and we see the first chapter of the Constitution, and we see very basic things. Our Constitution is the lengthiest Constitution of the world. Our Constitution is the result of a in-depth research of different constitutions of the world. Our constitution framers have taken this from this constitution, this another thing from another constitution. For example, if I say fundamental rights have been taken from which constitution? Can I just get the attention of the participants of this particular, FDP? All of you, I think this subject is constitutional law is across your specialization. And this part which I'm asking is of class 8th standard student, that fundamental rights have been followed, not totally borrowed, or I'll say. So from which constitution of the world? Just to attract the attention of the participant, I want to, it's not a question or it's not a very big deal.
It has been taken from the US Constitution.
Yes, so exactly. Not exactly taken actually, because we have a very elaborate document on part 3 of the Constitution, unlike, but the basic funda we have taken. Similarly, we talk of directive principle, we talk of emergency provisions, we talk of different things. So what I'm trying to tell you that it is not over time it has happened globalization. It is, I mean, my argument is, it is even at that point of time that or even today, whenever our judges are writing the judgment, not even today, one technology is there, even time immemorial since the Supreme Court have been created, whenever they are writing the judgment, there are precedent from other countries, isn't it? So that is also an example of globalization. So, I mean, and that is not only in case of India, it is actually in case of most of the constitution. So here, if you can see the first line which says, several countries' constitutional system, whenever they have been created, particularly those which are common law backgrounds, have habitually borrowed ideas and the court decisions from another country. It is not another, they are always in the habit of borrowing from one another. Even today, when our researchers go for a study, undertaking a research project, research thesis, we encourage them to do comparative study, isn't it? We encourage them to if there is a particular point today, for example, if they are talking about surrogacy, if they are talking about termination of pregnancy, or anything. So we just always talk them, or it can be anything. I just took 2 examples, or even talk of juvenile delinquency, we talk of women's rights. So we compel them, or we suggest them that they should go for understanding the other systems also, so that we can, tomorrow when you write a thesis, there is something new. You can suggest something, some good ideas which have been followed in those countries, and something which can be relevant, keeping in view our system also. I mean, we cannot absolutely abruptly take anything from any other country. It is definitely, we will take best suited for us. And then same was done by our constitutional framers way back when they were in the process of writing the constitution. They were in the process of framing the constitution, keeping in view our socio legal culture, our socio-economic backgrounds. So when decolonization took place in most of the part of Asia and Africa, including India, and that during the early year of United Nations organization, that is sometime in way back in 1920-25, it was a type of bigger type of overhauling of the world which was happening. And during that time, many of the constitution added clauses that were mutually similar. We all, for example, as I just said, our constitution framer have taken various ideas. They have borrowed many good things from different constitutions. Not only that, they have also based the principle which are found in the international instrument, that our things should be at par with the, for example, while writing the fundamental rights, apart from looking at the American Constitution, we have also looked at international instruments such as the United Nations Charter and the Universal Declaration of Human Rights, or it can be European Convention on the Protection of Human Rights and Fundamental Freedoms, which was enacted in 1953. and became a source of doctrinal borrowing of legal and constitutional system, not only of our country, of many countries. Similarly, the clauses of International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, they have all have the reference point for such constitutional borrowing in in the earlier year as well as in the recent years. So somehow it is always that, and then also whether we all these conventions and international documents, whether we have ratified them, whether we are party to it, that is also something which is very relevant when we talk of that we have taken many features. Accordingly, we have taken many features of the Indian Constitution, and it is not only we. The United States Constitution have been exported through international instrument in various countries, such as Bill of Rights, even judicial review of law, limits on the governmental power, equal protection before, in Article 14 of the Constitution, when we have two words, equality before the laws and equal protection of the laws. We always teach our students that one concept is of United States region, another concept is from United Kingdom's region. But in India, we have taken both the context, or we have more followed this US equal protection before the laws. So further, when we expand the scope of international human rights standards and the importance of international institution dealing with the issues, also trade liberalization, climate change, war crimes. These are the other areas. Trade liberalization is one of the most common where the globalization term have become popular. Nowadays, we talk of in the context of global change, climate change. Why so? Because climate change, when we talk of, when we talk of all environmental pollution, when we talk of all type of environmental issues, especially, especially when we say increasing temperatures, global warmings, other aspect of climate change, though it is our duty to tackle the aspect in our territorial limits, but the subject matter cannot be, because the sky have no limits in the context of you can create a territory. The sea have no, you can have physical territorial boundaries, but when it comes to climate, when it comes to the global warming, when it comes to different effect of climate, it cannot be limited. So again, here we have to understand it in the context of global. Similarly, war crimes, law of the sea, cross-border investment. So these are some of the aspects which cannot be actually looked so much in the only in the global context. We can definitely zero in somewhere, but it is not complete unless it is taken in the context of the global. Then today there is a trend towards convergence in the domestic constitutional law. And also there is no reason to prevent the judicial discussion between different legal systems. Why not? Why should not we take lessons from the judiciary of United States or UK or European countries? And why should not we share comparable ideas and the principle, especially when we have some availabilities also. We call it era of globalization, but era of globalization have facilitated, of course, by the advancement of communication technology. Because today, why I'll say further it has been facilitated, or we can call it era of globalization, especially we are talking in the legal context. So today, this advancement of information technology, ICT, have created so much of availability of the literature, so much of availability of all other countries, all other systems, information, legal material, and it has become considerably easier for us. In one point of time, for example, I say when I was a student, was it easier to have, in fact, it was a very, very rich affair, even for the law libraries sitting in the Supreme Court or sitting in the maybe Indian Law Institute or maybe Delhi University or maybe, some big universities, if you name, even for them, it was a very costly affair to subscribe those very costly international resources of law. So that was actually a luxury. It was very few people who were able to subscribe, because at that time it was a subscription. If you subscribe, then your library will have availability. So at the personal level, it was an impossible task. But at the, at that level, it was, to some extent, it could have been taken that maybe some libraries have it. But even most of the libraries, they were not in a position. But, if I take our country, and that is not in our country, that was across the world, except some very rich economies. But most of the countries were not able to subscribe those foreign law reporters and legal reviews. In fact, here you can see the word prohibitively expensive. That means it was so costly, it was so expensive that it was putting most of the law people, even practitioners, even judiciary, even educational institutions out of the reach, leave alone the personally. But today, this digital revolution have drastically altered the situation. Whatever you want, it's available to you, isn't it? Not only at that library level, at that university library or Supreme Court library or the lawyers library, which are the big domains, even at our personal level, we can explore everything. We can explore each and every literature, each and every law reporter, each and every legal review or journals, at the cost of or at the click of one button. So it has become very easier to make it that globalization, which was there, our constitution makers have that mind to use their provisions, to use their judicial system, to use the judicial review process of America. But it was not so reachable at that point of time. Today, it is so reachable, isn't it? Even you can see the videos of the judges of their courts, how they are giving precedent. But it's still, of course, in toto, we are not following the judiciary, because in our system, we have lots of petty nature cases. Our pendency rate is very high. And the way our judges are overburdened, our judges are overworked, our judges are taking many cases in a day. Their system is please, I think while I'm saying the whole takeaway of my lecture will be with regard to, please just see how the US judiciary works, how efficiently they are given time. On one particular case, they may give the whole day hearing, and they have a rest time also in between, unlike our judicial system. So there are still gaps. I mean, despite having approach to the things, our people are not having time to explore that material because they are overburdened, and that is one of the flaw of the judicial system, which should also be actually taken lesson from the other countries. Then I should not move away from my topic. Already I'm late, and I, as a professor, start generally going to teach you more in a particular point. So let me just, and that is why I'm using these slides, because otherwise I could have gone so much into one point and then elaborating it too much. So, we can see that most of the constitutional court judgment are posted publicly. They are available on website. They are allowing simple access from anywhere in the world. Even nowadays, even our judgments are so quickly available. Abhi 11:30 baje kuch bhi judgment hoga, to aap 12 baje bhi use padh sakte hain. So that's a development. Earlier it was not so. जब तक महीने का आखिर हो के आपकी AIR या और वो भी अगर आपकी लाइब्रेरी में आ जाती है time, isn't it? Only then that time you was having an access to that judgment. So and now we have many commercial online database that have made it possible for the judicial practitioner and the law student around the world to easily access information from different jurisdictions. So that's one of the development. Then reliance on the foreign precedent. The Supreme Court was always in the habit of relying on the foreign precedents. Precedent, you all understand, I feel. You know what are the precedents? Precedents are some of the judgments, some of the previously decided cases that can be of our own country also, but that can be, here I'm talking about the foreign precedent. So our judiciary, if you look back, you read some old judgments even, and even if you go, the most famous cases which always people refer to, Keshwananda Bharti and all, you will see the foreign precedent which have been cited by our judiciary at that time while talking about the basic structure of the constitution. Okay, so it is always there, but today it has become easier. Today it has become much easier. That time it was requiring lots of study, taking the hard copy of the books, but today, and then when availability of that copy, but today it is very easy. So many socio-economic aspects of globalization are also consistently reshaping the operation of our judicial system. Like in certain type of appellate litigation and adjudication, when we put our reliance on the foreign precedent, it is required. And today, even the higher court and the lower judiciary can have precedent on on their trial court judiciaries, which was not earlier available. And actual location of parties in different jurisdiction make a necessary mention and debate foreign statutes and judgment in litigation, which are involving cross-border business activities, many of the family-related matters, whereby parties may be from originally India, living anywhere else. So that is another subject matter. For example, we all know private internet. And every one of you might have studied public international law, but few people know about private international law, to what we also call it conflict of laws. So local courts are now being asked to deal with the international legal document in areas because initially the case emerged before a local court, trial court, and to look into the subject matter, whether it is, lex loci, lex fori, that is jurisdiction. These are the terms used in the conflict of laws, which I have not put it here. But many of the things, whether it is their, status with regard to nationality, their, their residence, there are multiple terms which are coined when you talk of personal matters. Similarly, when you talk of contract law, so private international law have become further relevant in the context of globalization. And the globalization is from multifaceted ways. People are living across the world, belonging to one country, living in another country, a job in another country, a child is born in another country. Similarly, contracts happen. It can be commercial contract, it can be, so that too among different countries. So even today, local courts are being encouraged to deal with international legal documents in the areas of the conflict of law, whereby, they must rule on the matters like proper jurisdiction. I already said lex fori and lex loci. Choice of the law a person have, that also is the availability of the context, choice of law, and the recognition and enforcement of that foreign decree and the arbiter award in the country of their choice. So these are some very relevant things which are more relevant in today's context. I mean, recognition of foreign degrees is always there in our CPC if you pick up our civil procedure code, but it has become very relevant in this time of globalization, in this time of time when lots of private international law and conflict of law is, being availed by the parties. Then respected countries who are parties of international instrument, they are bound, so because one thing is there are some international document, international instrument, international conventions which are existing there, we can look at. But on the other hand, some of them, if a particular country have ratified, have, they are party to it, they have treaty with it, they are ratifying that convention and declaration, more in their context, it become very, very necessary to follow accordingly. And the domestic courts are compelled to investigate the text and interpretation of those documents, because we are having a treaty, we are having a convention ratified, and so it is necessary for us to look into those documents when we are giving any judgment. So there is a room for argument when it comes to citing international precedent. That is always a subject matter of debate in our country. Whenever the judiciary or maybe some lawyers, they are citing international precedent, especially in the circumstances where local law is not giving much clarity. Because generally precedent is opted when we have less of local law, less of clarity in the precedent available in our country. So but there is some argument, and there are some people, some persons who voice their opposition to the use of foreign law. Particularly the cases are involving some sensitive constitutional problem. But however, everything have pros and cons, but more I will say that it is very much nowadays used, and it is very much nowadays popular, whether in case of, personal laws, whether in case of contractual laws, whether in case of our constitutional borrowings. So second point, I'll talk about the encouraging foreign investment. That is because globalization, as I say, is most related to, in generally, if you will find out or understand globalization term, more with the economy, more with the, investment. So this is one area which of course need justice, also need litigation. So whenever there is bilateral investment treaties and free trade agreements, which are very commonly being nowadays used in the context of attracting foreign investment and to protect the rights of the company and invest in other countries, because that is being encouraged from the governmental side also, that there should be more and much foreign investment and companies. So now how to protect those companies, those who are involved in the foreign investment and they invest in other countries, their funds and their, their money. So such treaties, if there are some treaties, bilateral investment treaties, they impose responsibility on the host government to provide fair and equitable treatment to foreign investors, as well as favorable tax and regulatory scheme and protecting against unlawful expropriation of the money. So this is an area which is more popularly known in the context of globalization. With the exceptional openness in commerce, banking, travel, communication, that had led to economic progress and well-being. Also simultaneously come, I'm not focusing on this area because this is another big area which those who are into commercial laws, who are into all these trade investment laws, etc., studying. So this is a subject matter to be taught in various semesters. So I'll leave it here. I'll come to a point whenever all this happens, all this investment and bilateral treaties. So it also leads to organized crimes. It also leads to crime that has been affected by the globalization and have become a more serious type of, when earlier crime was something which is within the territory and the jurisdiction, whether with regard to confinement, whether with regard to punishment, whether with regard to application of law, very much it was, it was your home affair. But today, because of many of the things, not only the aforesaid, but many of the things, they have led to the creation of the organized crimes. And that has affected the, trade globalization, and it will become a very serious subject matter to be dealt with. It has also generated very many opportunities for the criminals to grow with illegal enterprises. When I talk of globalization in the context of commerce and trade, it has also given opportunities to the criminals to grow their illegal enterprises. It has not only changed the nature of the crimes, but also changed the types, forms, and the nature of the criminals, victims, and the venue. You commit a crime at one place, it affects the person at another place. So the means of moderate crimes in the age of globalization have become much more developed than before. And the way, money is transferred in a second. We all, many of you might have been duped also. They ask for your password and within seconds your account is empty. So again, this is an area which we all understand how the criminalization have become different than in the context of globalization. So in that context, in almost all criminal justice system, they intersect, they have to communicate, and they have to collaborate with one another, because that in that case, money is at one place, criminal is at another place. The thing happened, they have no territorial jurisdiction. Money is lying in an American bank. It has been, duped by a person sitting in another European country or in India or in Pakistan, Bangladesh. So what is the way out? That criminal justice system also have to intersect, communicate, and collaborate with one another. They have to, have some autonomy and international worldwide assertion of criminal jurisdictions, because that put pressure on the traditional concept of a single nation state having only ability to punish the persons who, and once a person crosses the border, become absconder, and we cannot, unless we have a treaty, unless we have a type of international collaboration with that country, that you will surrender, you will make that offender available to us, or you will, so that also many cases we often see, whether it is the recent, I just forgot the name of this fellow who was a diamond merchant and all. So this is the way they take out. So this is the need of the hour, that the criminal justice system also should be, apart from having only those extradition treaty and all, if it is not, they generally abscond to the countries whereby they feel that the Interpol police or any police will not bring it, because your country is not having any extradition treaty with that country. So all this also required a little more extension of the criminal justice administration, criminal justice system also. Yeah, so quickly finish. I will just come to how much role of technology and then further role of artificial intelligence in the context of globalization of law and justice. So we know that our judiciary, especially our judiciary and more so the judiciary across the world, they are designing, developing and implementing the artificial intelligence in their judicial system. They have become, AI have become forerunner of the judiciary nowadays, but it should be used simultaneously. The issues have also come. So, I mean, just skipping this slide where I just want to tell you that NITI Aayog have already took note of that AI should not be misused also, because it can be, the things can be misused also. There are ethical issues also. But however, our judiciary as well as judiciary across the world, our judiciary, why I'm saying, how we can take the help of globalization, how we can take the best benefits of the other countries. So we have taken a quantum leap in last few years, thereby we have fully grasped the possibility of cutting edge AI technology, which has many things to offer. E-courts are there, e-court mission mode project. Then there are technology to increase, different type of institutional efficiency, such as this SUVAS. SUVAS is, I don't know how many of you heard about it or not. It is a neural translation tool, and it has been introducing in the Indian court. SUVAS is basically a language translator, SUVAS, and then another is SUPAS. So all these tools, which was not the possibility in the earlier times. You cannot translate each and every document in every language. So these tools are helping the court. And when a perfect judicial system, you need that, even the books. I mean, you can get everything translated with the help of this document. So this is also helping the globalization, that everything which is produced either in the court in the form of evidence, or it is anybody want to read any document. So use of AI in the judiciary, use of AI in the law, use of AI in the whole process of understanding the different cultures has been very well used. And every day we are using different type of, Supreme Court have an AI committee, and they are claiming that AI would be employed for and actually every day. Today I'm talking, maybe they are one step ahead for the purpose of using all this technology and AI for speeding up the processes. So we can, I mean, there are multiple ways whereby it is being used and it is being planned and implemented. So while I'm saying this, you must be wondering that what is the status of other countries, how it will be helpful. In fact, I'll say that in our country, it is still in the infancy. It is being applied in various aspects of the judicial system across the world. Look at, like, for example, UK is using to predict the reoffending the criminals. See, once a criminal comes into, in our country, what is the process right now? That a case goes on, and ultimately whether either person is acquitted or convicted. But once a person is acquitted or even convicted for some small offense, the person is gone after the bail or after maybe final release. But how to have a control over reoffending criminals? I mean, they still keep a track. Maybe the recent law which we are talking about is of some type of that will analyze the DNA and all of the, of the criminals. But we don't know how much used and misused will it be. But UK is already making use of AI to predict the reoffending criminals, or to keep their track despite they being released. So then Estonia is, to adjudicate all small court through robot judges. This is another good thing which India can borrow, because we have multiplicity of the and that will be a good example of globalization also, because we have multiple number of cases because of which our judiciary is already overburdened, which are small cases, but they are pending in the court and increasing the pendency of the number of the cases. So if such type of thing is followed and it becomes successful in our country, it will be a good example or take away from, with the help of globalization of law and justice. Then China, Russia, and Mexico, they provide legal advice and approve some small things which are again pending in the court of law or pending with the government offices, such as advising government officials and approving their pensions and tracking their pensions. So this is being done there. Malaysia is taking the help to support sentencing decisions. Then Austria is using, sophisticated document management system, which our judiciary is also, to some extent have come into how they will have case or court management, court file management with the help of, we have lots of paperless in every office, including the judiciary, including law offices. So maintaining the document is another use of the technology and help globalization. We can send a document in a second to another jurisdiction. Earlier, it was not the case. You have to post, you have to send through different methods, and when will it reach? First of all, longer time, then whether it will reach or not, that was another issue. So again, Colombia and Argentina, they identify urgent cases, and in Singapore, they transcribe court hearing in the real time. And then to improve administrative efficiency, task-specific, narrow tailoring algorithm, they have been trained through, of course, machine learning. All what we say, this technology, it's machine learning. It can be used to automate common administrative processes, such as scheduling of the hearing, preparing cause list. I think already this is being followed. And that best part is it is available to everybody. When once it is in the technology domain, anybody can look into. So some of these things, discovery of the documents, review of the document, all these have been helped in the context of globalization and technology. Then lots of smart e-filing, intelligent filtering, prioritization of the cases or notification, and case monitoring. These are the procedural tasks which have been expedited with the usage of technology. Then many of the intelligent analytics and research work to supplement human decision making. Then computational technologies that can be utilized to speed up the delivery of justice in cases such as traffic challenge and motor vehicle compensation claims. So these are the, these are the lessons which we are taking from other countries and following it with the help of technology. And that is happening because of two things. First of all, globalization, in which we are believing, lots of movements of parties, lots of movements of properties from one place to another place, and the help of this technology in that actually made the life much easier. So before, potentially developing more complicated algorithm decision-making tool, lots of assimilated learning from, first generational technologies and boost the administrative efficiencies. There are many challenges also, which are also to be dealt with simultaneously. Sometimes people feel it creates inequality among the people. It creates, because there are all type of populations, especially in our country, when I'm talking about especially globalization and the use of much technology. Many of the people who are either poor or sitting at places where the availability of the technology is not there. So in their context, and India have a bigger population of that type of people. So in that case, all that what I right now says may not be a beneficial thing or may not be available. And in that case, it may be a very biased type of further facilitation and talking about that we are such much benefited by the globalization of law and justice. So now just to conclude what I say, that from whatever I said from the perspective of different countries, legal system, we have already learned a lot. We can learn a lot from one another, both in terms of institutional architecture and the growth of the procedural as well as substantive laws. With increased cross-border commerce and investment, it is now critical that all engagement which are appropriately in multilateral rulemaking and dispute resolution process. They're also providing a balanced response, of the complex situations through our domestic legal system. Judges, lawyers, professors, even law students from various nations, they have today lots of possibilities to communicate, to collaborate, and learn from each other's experience in the age of this globalization and the technologically driven. Actually, we are doing that. Like, for example, I will just conclude to say the last word, that what I said, I just want to connect it with all of us all the time. Just conclude that today we are sitting in this webinar or FDP. We can connect anybody to it, isn't it? We can connect any resource person from the world to it. We can connect any participant to it. And that gives us lots of learning. That which was not earlier possible unless you get a huge either some sponsorship or your own money to travel to go to that place. So lots of hurdles which used to come in your way to be a part of that, which today is available just as it is available to me, to the next of our person, it is equally available to me. So that helps, I mean, the whole world, including the law and justice of our country. Thank you.
Thank you, ma'am. It was indeed an enlightening and informative session from you. Ma'am, there are certain questions that have been put forward from the participants. Would you like to address them?
Yes, surely I will.
Okay.
Provided you have time, because I have missed on time also, isn't it?
Ma'am, we can do this quickly. I mean, there are certain questions, 2 questions.
Surely,
with your permission.
Yes, I'm.
Okay. So, ma'am, the first question is, with changing legal spectrum in India, which can be seen in the Supreme Court judgments given in the cases like Navtej Singh Johar and Joseph Sain, can we say that these interpretations are results of effects of globalization?
Yes, to some extent, yes, and to some extent, I think even even in our country there was lots of compulsion. But here again, I'll say Supreme Court have taken a leap. Supreme Court have gone forward, and when our Supreme Court gives some judgment, it is binding on the parties and to all of us. However, culturally, I feel if you talk of Navtej Singh, I mean, if we talk of whether same-sex marriages, whether live-in relationships, whether recent that adultery judgment also. I mean, there are many things which we take it in India as a cultural society across the religions, across the cultures, across the economic background. We still take it as a dilution of our cultural things. Like, for example, marriage is a very, 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 what I say, it is sacrosanct, it is something very pious, it is something which is a relationship in our country, which is very, very, of the type taken in a particular, in a cultural manner. It's binding nature, it's, follow up. But when we talk of things like live-in relationships, and when we talk of, as you said, Navtej Singh, when you talk of same-sex marriages, when you talk of various type of other legalization of things which are happening time to time in our society through with the lens of the judiciary. So in a way, it will create a balance slowly and gradually. And of course, yes, it is a result of course, globalization, because we always take the things, what is happening in other countries. For example, same-sex relationship, homosexuality, transgenders. In fact, when we say LGBTQ, there are furthermore new terms which are added to every day. So not only in the context of marriage or living in fact, in the context of various other facilitation to these communities, which are yet to come from the Supreme Court or from the society, maybe facilitating them at places, maybe facilitating them in terms of their special, places to say, toilets, their title, even in the form which we fill at times. We have Mr. or Miss or Mrs. or Doctor or Professor. We have never have anything, but now it is also coming. Similarly, when workplace, when we employment to be given, this is another area which will open Pandora box if I'll start talking about somebody who was appointed to be a judge but was denied that, somebody who was appointed in another position but was denied that because of a particular thing. So this is a long way to go, but yes, globalization is definitely helping the judiciary to come way forward. And I'm sure it will come forward in another context also. And slowly and gradually society will accept, because it is not yet accepted in the society. And I'm also a part of that society. All of us are part of that society. Thank you.
Okay, ma'am. The second question is, what is the status of private international law in matrimonial area in our country? What sort of challenges do we face in this era?
Yeah, first of all, I'll suggest you to read Paras Diwan book, I think, on conflict of laws, the basic book, which will be more helpful than from me, because, but it is there, but there's lots of private international law in family affairs. In fact, the term conflict of laws is very apt when we talk of, the family matters. Of course, there's contract also, there's tort also when we talk of private international law and conflict of law. But with regard to personal laws, it has developed a lot. It has come a long way. In fact, now many universities are offering this subject as maybe as their elective paper or maybe as their compulsory paper, because there is lots of requirement. And if somebody younger is asking this question, they know that there are many younger people who are living abroad, belonging to this country, going there, marrying a person from another country. So there's lots of scope. There's lots of way ahead which will be required in future to understand. And then there will be, it is not only nationality or place of residence, it is other words also comes into play, place of residence, place of location, place where your workplace. So there are multifaceted things, and place where you got married, place which culture you have followed. So there are different jurisdictions which comes into play. So this subject is just definitely have a long way forward. And because आप सब में से भी कई आज रहे इंडिया में, रहे नेशनलिटी यहाँ की, जाके वहां रहेंगे, शादी दूसरी कंट्री के बच्चे से कर लेंगे. So I mean there are multiple aspects of it. I think you are muted, Swati.
Thank you, ma'am. Thank you for taking out your valuable time for this session. And we also look forward for similar sessions in future. Thank you, ma'am, for your presence.
Thank you. Thank you. Can I leave now?
Yes, ma'am.
Are there any group picture of some
ma'am, it will be shared to you. It will be
there
shared.
Are some, have you taken some?
Yes, ma'am. We have taken screenshots and, whatever, the videos even.
Are you Preeti or Swati? First, let me just ask you before I leave.
Sorry, ma'am?
Are you Preeti or Swati?
I'm Swati. Preeti ma'am is also there in the session.
Yeah. Okay, because Preeti approached me calling while there was a difficulty and, Okay, thank you so much.
I am just a moderator for the session, ma'am. Preeti ma'am is also there.
Yes,
okay.
Yes, ma'am.
Thank you, Preeti. Thank you. Can I leave the session now?
Yes, ma'am. Thank you.
Thank you.
We'll just wait for another 2-3 minutes for our next speaker to join with us. I request all of you to just wait for some time. Thank you. Good morning, sir. Azim Khan, sir. Sir, you're mute. Good morning, sir.
Very good morning. Very good morning to all of you.
Okay, so can we start with the session?
Yeah, please.
Okay. So welcome back, everyone. We have with us Professor Dr. Azim Khan Pathan, sir. Sir is presently the head of department at GD Goenka University. Sir did his bachelor's in law from Amravati University and his master's in law from Nagpur University, and has been a recipient of 4 gold medals in both the courses. Sir has done his research in international environmental law from Nagpur University. Sir has initially worked as a legal practitioner, but later joined academics and has experience of working with reputed colleges and universities like Nagpur University, HNLU, UPS Law College Dehradun, Galgotias University, etc. Sir has worked in many academic committees, board of studies, and NAC committees, and his areas of interest are energy law, environmental law, and comparative public law. We welcome you, sir, and I would like to request Ms. Divyasha Dubey to kindly present a memento as a token of appreciation from us.
Thank you so much.
Thank you, sir. And sir will be speaking on the topic interdisciplinary approach in contemporary legal research. Over to you, sir. Thank you so much.
Thank you. Thank you so much, Dr. Swati and all management of Asian Law College and all participants, faculty members, and all research scholars. Indeed, today, the topic with which I'll be talking about, excuse me, in the context of interdisciplinary approach in legal research. It's a significance, it's a dynamics I'll be talking about on that aspect. And I'm sure this particular session, it will be more and more, two-way track discussion. I want that this particular session will happen, based on a Socratic method. And absolutely, this particular, important area, which is one of the important, we can say, the emerging areas which we have to, take into account as a researcher, as an academician, and absolutely, as a legal practitioner as well. That interdisciplinarity, how exactly it is now influencing this legal research and legal education. Every day we are seeing that how law is indeed getting influence, especially from other disciplines, because interdisciplinary research, when we are talking in the context of legal research, interdisciplinarity, when we are talking in the context of legal research, in a simple sense, we have to first of all understand interdisciplinary approach. It is nothing but where the different doctrines, different concept, different tools, different mechanisms, different, we can say, the ideas from other disciplines that is being molded, that is being blended, that is being synthesized for bringing out a legal solution, for bringing out to resolve many complex problems and many complex issues with which our legal system is presently confronting with. So in that context, as a researcher, as a teacher as well, our work becomes very important to understand the important nuances and contours of interdisciplinarity, especially in the context of legal research. I'll be talking in the context of this particular topic, but let me before that, just share this particular screen and slide just for the sake of your reference. My screen is visible there.
Yes, sir, it is visible to us.
Okay, so let me share. Hope my slide is visible now. All right. So let me, go ahead with our discussion point, dynamics and significance of interdisciplinary approach in legal research. This is the topic for today's session. I just want to explore with you all. And let me go ahead. Now, when we are talking in the context of law, when we are talking in the context of legal research, we are seeing that law is not exactly independent discipline now. Law is not exactly limited to now only doctrines, principles, rules, regulations, statutes, or statutory provisions. The different complex issues with which we are confronting with, we means the entire legal system, right from judges to the legal scholars, to the academicians, to the different research scholars, to doctoral students. When we are talking about the legal research, we have to understand one very important basic point. Now, law is not exactly independent discipline. It is getting influenced by other disciplines. It is getting and carving out the important nuances, doctrinal approach, different concepts, different perceptions, different ideas, different statistics from other disciplines. Let me give you the example at the threshold. Now, in medical jurisprudence, we are continuously talking about, and we are closely and carefully and very, closely we are observing that. Now, how exactly in medical jurisprudence, and more specifically this medical, the field, you are finding that there is application of, the artificial intelligence. There is application of, the robotics. There is application of, the different software with which, the doctor who is sitting in the United States of America is, performing the surgery or performing the surgical incision with the help of certain software, with the help of artificial intelligence, with the doctor who is sitting in the Singapore, or doctor who is sitting in the other corners of the world. So similarly, when we are talking about the medical jurisprudence or the other fields, they are growing based on the other disciplines' knowledge base. Equally, the same analogy is also happening, and the same important, the process is also happening in the legal research. The law and legal research is also getting continuously influenced. Continuously, it is imbibing the other disciplines' knowledge base to bring out the solutions to the existing problem. Now, let me give you the example at this juncture when we are talking in the context of, this 21st century. Now, we have seen, more specifically in the many, jurisprudential thought and jurisprudential, the classes as well and the discourse as well. We had already seen that the law, how exactly it was going, or how exactly it has been propounded by different authors, different jurists. That how law, legal research is getting influenced by the societal requirements, the sociological engineering, the Roscoe Pond's idea with reference to, social engineering, where he stated that the law is nothing but the social engineering. Different interest groups, catering the needs of different interest group. That is ultimately the purpose of law. That is ultimately the purpose of any particular rules, regulation. Similarly, we have seen in 18th century, 19th century, more specifically, the thought, the philosophy with reference to historical school of jurisprudence in the context of growth of the law, where Sir Henry Maine says that law grows with the growth of society and law dies with the death of society. That was also yet another important approach. We have also seen that how exactly law it was growing with the important, premise or the thought of, Austinian jurisprudence, where he stated that no, law is ultimately command of the sovereign. Subject has to obey. It has to be backed by the sanction. It has to do nothing with that of any kind of component like, morality or ethics of the natural justice, principle. It has to do nothing with that of, more specifically, the natural justice philosophy. It is purely based on command of the sovereign. So these are certain approaches with reference to growth of the law, with reference to, we can say, the emergence of the law, or we can say the different legal norms or different important, thoughts, philosophy, how law is growing, how legal norms are growing in the society. But to your surprise, now this 21st century is purely, based on the very basic premise and very new important, emerging area where we have to say that law is now growing with the growth of technology. And that is also yet another important basic component of interdisciplinary approach to resolve the many important emerging issues with which the legal system is presently confronting with. I'm saying that the 21st century, we have to say that now, based on our, different updates or different important, happenings with which we are now surrounded with in the society, where we have to say that now law is growing with the growth of technology. And that is nothing but the new jurisprudential thought or jurisprudential, theory which is emerging in 21st century. I am remembering here the very important, the jurist who has done a lot of work on clinical legal education, and you can find his, very important journal based on, empirical research. Lee Lowinger, he had stated earlier that in earlier century we have stated this particular premise that necessity is the mother of the invention. He stated so. But now he further elaborated that in earlier century we had stated that necessity is the mother of the invention. Now we have to, say that invention has become the mother of necessity. Invention and innovation has become the mother of necessity. Why? How? You cannot lead the life without the access of internet. You cannot lead the life without the, without the help of smartphone presently. No individual on this particular planet Earth, no doubt, we are not talking about that digital gap. But here we are talking about in the context of no one is able to lead the life in a dignified way without the help of technology, without the help of, we can say the mobile phone, smartphone, without the help of internet, without the help of social media. Now the entire social relations as well are based on the degree of utilization of the social media or degree of utilization of cyberspace or degree of utilization of the technology. The entire, we can say, the system, legal, we can say the norms are also growing based on, the technological interface. You take the example of yesterday. You take the example of day before yesterday. How exactly system is also, trying to not only, we can say the continent, our Indian continent, but all over the world as well. If you will see carefully this particular, important emerging trend where the successive governments, they also wants to regulate the cyberspace. They also wants to regulate this particular, the internet, they want to also regulate this social media. We have also seen recently, many important updates. No doubt, this 2019, this bill which was introduced and which was in front of, Joint Parliamentary Committee, it had been withdrawn with the commitment and with the promise, saying that we are coming with reference to or with the help of comprehensive legislation, based on the international standard. No doubt, this is also yet another important domain. Besides that, we are also continuously seeing that how exactly, internet intermediaries, or we can say the intermediary guidelines, Media Ethics Code 2021 rule based on the Information Technology Act is also trying to regulate this, important, contours of this internet, or we can say information and communication technology. Besides that, if you will see carefully, if you will try to understand carefully international trade, more specifically transboundary trade, transboundary transactions, drafting of the contract, even the dispute settlement with the help of online dispute resolutions are, continuously happening. During COVID-19 and amid COVID-19 as well, we have also seen how, very aggressively, this cyberspace and this digital space that has been utilized by the administrative body to judicial organs of the country, not only in India, but if you will see carefully other, the countries and their experiences. More specifically, if you will see carefully the experiences with which we have also confronted during this COVID-19, we have also seen the many important new policy formulations are also coming in many countries. Like take for example, Chile, they have changed their constitution. They stated that, okay, all right, to deal with such a situation like this, pandemic, or like this, the health hazard related issues, we have to have certain virtual hearing for the lawmaking process. On 22nd April 2020, the first time United Kingdom and the Parliament of United Kingdom, they sat together virtually for making the rules, making the laws, for dialoguing and discussing. During COVID-19 and continuously, we are also seeing that how exactly standard operating procedure that has been carved out from the side of Supreme Court of India, from the side of, different high courts of the country, for access to justice, for giving access to justice. For your surprise, you will also understand that, and you will also, and I'm sure you also must have, seen the observation of Justice Deepak Gupta, not Justice Deepak Mishra, in 2018. When the issue with reference to, this LinkedIn, social media, this WhatsApp, this, different media houses, they had approached before the Supreme Court and different high courts in the context of, banning on their, these social media activities. At that particular time, Justice Deepak Gupta was having a specific observation that this entire now system is also working, a bulk of major system and major transaction, black marketing, that is also happening under the, guise or under the cover of dark net, or we can say deep net. So to resolve these issues, the different disciplines, nuances, different disciplines, knowledge base, or the technologies, knowledge base, and its doctrines, its philosophy, its ideas, its statistics, its information, its data, that has to be properly connected, that has to be properly blended, that has to be properly synthesized to bring out the new solutions, to bring out the new, important theories, to bring out the new important, we can say, the ways, solutions. So in that context, we are saying that now law is growing with the growth of technology. Now law is not exactly growing with the growth of, just like in earlier century, we have seen law is growing with the, no doubt, based on the societal experiences, populist approach, populist opinion, or law is growing based on, the different moral thinkings, or more specifically natural justice, philosophy or principle. But now we have to say, looking to the surrounding, the updates surrounding the happenings. And now law, you will also find that it is also growing in real time. Because to tackle and to deal with, these real-time issues of technology, real-time issues of, we can say this technological growth, law has to also be based on the real-time problem solutions. The law of 2000 Information Technology Act, that cannot work in 2020 unless and until there is, proper revamping, understanding the nuances of technological growth, understanding the nuances of the cyberspace, or understanding the nuances of, these all cyber crimes or all deviations which are happening with the help of, this entire cyberspace. So law has to also cater the need of real-time changes. So accordingly, the legal research has to also match to bring out the new solutions based on the other disciplines' knowledge base. When we are talking in the context of law and technology, you will surprise to know that how interdisciplinarity is reflecting now presently in present day context in the legal research, in the decision making, in the decision and different, judicial discourse as well. The best example we have to also understand recently how law is growing with the growth of technology. You will find this, a very important and very strong example by way of Fahima Shirin versus State of Kerala case in 2019. Where directly High Court and Justice Asha, the single judge bench opinion, which has become one of the important landmark judgment for the entire country. For the entire country, I am saying. How interface of other disciplines, knowledge base that has been, taken into account to bring out the solution, to bring out the new interpretation. And how exactly interdisciplinary approach that is reflecting in this particular, judgment. You have to understand that particular point. Many of you must be knowing about the very background of this particular case. I am not going into detail in that particular case background. But this Fahima Shirin, when he was restricted, from using her mobile phone or, laptop or social media and internet facilities inside the hostel, by the hostel administration, she had, approached before the High Court of Kerala, saying that there is clear-cut violation of right to education, clear-cut violation of right to life, clear-cut violation of freedom of information, clear-cut violation of right to know and right to education. See how beautifully single judge bench she has brought the analogy from other disciplines while bringing out a new interpretation in the legal domain, in the legal norms, in the legal research. Justice Asha, she has, taken into account, some important international instruments which are continuously growing at the international level with reference to, this internet, with reference to, freedom of speech and expression. Because if you'll go back and see the Universal Declaration on Human Rights, see, we have to keep open, our eyes and mind for bringing out, bringing out the new interpretation from other discipline to resolve the existing problem. Similar approach that has been used from the side of Justice Asha in this Fahima Shirin versus State of Kerala in this particular case. She has taken into account the international legal instruments which are continuously growing at the international level. 2016 United Nations Organization, they had brought this non-legally binding document. No doubt that was the resolution. No doubt that was the resolution from the side of United Nations Organization and their Human Rights Committee, where it has been stated that access to internet is also human right. Access to internet is also part and parcel of human right. This particular legal instrument, and at the same time, if you will see and properly, carefully, analyze the international legal instrument, including Article 19 of UDHR, Universal Declaration on Human Rights, you will come to know that Universal Declaration on Human Rights, Article 19, it says that free speech, freedom of speech and expression, that has to be facilitated by any means and mechanism. And that is the part and parcel of human right. So see, this particular legal instrument, other, 2016, the resolution by the Human Rights Committee that has been taken into account by the single judge bench in Faima Shirin while, deciding this particular issue. And when we are talking in the context of, United Nations Organization, they had also elaborated and they have gone further, elaborating on this particular premise that human rights, whatever are available offline, that should also be available online. So these are very, very important premises, legal propositions. We have to keep our mind open to understand those different important legal propositions. And one other important facets for promotion of fundamental right, for promotion or protection of right to education, which is guaranteed in Article 21, capital A, and more specifically under right to life, which has been recognized. The Justice Asha elaborated and extended that particular version, saying that how without a proper information, without the access to the internet, how these all online resources, including University Grant Commission, SWAYAM courses, MOOC courses, which is available online, how any particular student can access and can get that particular education if there is no proper access to the internet. So see, one side, technology is growing, and that technological growth is impacting our existing legal norms and existing, we can say, the legal thoughts, or existing, we can say, the law which is declared presently by the legal system. I am going further. When we are talking in the context of, law and technology, let me give you the example of, Paramveer Singh, Saini versus Baljit Singh. This is the case of 2020, which had come before the Supreme Court of India. And you will surprised to know, after 2015, in the context of D.K. Basu versus State of West Bengal, where the important issue, important guidelines, it was given from the side of Supreme Court for protecting the human rights of the jail inmates, or protecting the convicted people, and their human rights inside the jail, different important means, mechanism, measure that has to be adopted. With reference to that particular guideline, this Paramjit Singh Saini versus, Baljit Singh, this is the case of 2020. It had given a new analogy with the help of, growth of technology. With the help of growth of, this technological advancement. The Supreme Court is saying that for protection of human right of those convicted people who are leading their life inside the jail, or, those alleged people, when, FIR is being registered against them, that particular process should be more fair enough. And for that, and for their protection of human right, this information and communication technology compulsorily that has to be utilized, and CCTV, high-powered CCTV that has to be installed in each and every police station of this, each and every segment of this entire country. Each and every state, there should be central, high-powered committee. There should be state high-powered committee or monitoring committee. There must be, that is the guideline from the side of Supreme Court. There must be district monitoring committee, and these all committees, right from center to district level, they will see, they will understand, they will review. This all installation of CCTV in each and every police station, so that entire process of investigation and registering the FIR and registering the all kinds of we can say statements of alleged people, statements of witnesses, that would be in a fair manner, that will be conducted in a fair manner. So see, human rights are also getting influenced with the help of technology. Human rights are also getting influenced with the help of information and communication technology. The best example we had also seen earlier in Shreya Singhal as well. Even freedom of speech and expression through internet, that has also been considered as one of the important facets of right to know and right to information, and more specifically freedom of speech and expression. While striking down that section 66 capital A of Information Technology Act. At the same time, how exactly we are finding that this technology is continuously impacting, influencing. This discipline is continuously is also providing the new solutions. We have seen the best example, that Anuradha Bhasin versus Union of India. This is the case 2020, which had come in front of or before the Supreme Court of India in the background of special status of Jammu and Kashmir, when it had been taken back by the presidential order. Then in that context, when there was this shutting down this all internet and internet facility, internet access in that particular region. So in that background, this Kashmir Times editor, this Anuradha Bhasin, had approached before the Supreme Court of India, saying that their business, their free speech, their freedom of press, that is being influenced, that is being breached, that is being breached, that is being violated. So in that context as well, Supreme Court of India, till then, all kinds of those order had been taken back from the side of Supreme Court, had been taken from the side of central government and the from the side of presidential order with reference to shutting down all internet services in that particular region. But Supreme Court had also come up with this particular opinion, that for accessing the human right and for protection of human right, for protection of dignified life, this free speech, freedom of speech, access to internet, that is also paramount, and that has to be also properly regulated based on the proportionality, based on the necessity. That particular doctrine, it had got also evolved based on this particular the instance, this background only. So we are seeing that how continuously technology is influencing the law and the growth of law. You go back and see, and you find out, you take out any legislation, any rules from the Ministry of Law and Justice, or from the Ministry of Commerce, or from the Ministry of Broadcasting and IT Ministry, you will find that there is clear-cut interface. There is clear-cut inclusion of technological interface in the decision making, in the administrative decision making. Let me also provide you how exactly new thoughts or new research or new important disciplines are also going to provide the new solutions or the new way forward for deciding, and more specifically for bringing out the new solutions. Now we are continuously talking about The legal research, we are continuously talking about law is growing or legal research is growing based on the other disciplines knowledge base. Now many complex issues are also cropping up. Now every day we can see on Play Store different kinds of new apps are coming on Play Store. New complex issues with reference to copyright, that is also cropping with the help of cyberspace, that has to be tackled with the help of law, and that too real-time law. Now the new domain is also emerging, where we are saying that digital medicine is emerging in this country. All over the world, digital medicine is growing. Many complex issues are also cropping up. So to resolve those complex issues, we have to understand the other disciplines knowledge base. Practice, processes, treatment that is happening with the help of internet, that is happening with the help of internet service provider. The internet, or we can say with the help of internet facilities, the one doctor who is providing his prescription or his test with the help of internet facilities to the patient who is sitting in the other corners of the world. Digital prescription, digital medicine, that is also growing, and it is also bringing with its new issues. We have also seen currently and presently the new issues in the context of this drone technology. But drone technology is also growing, and it is also impacting based on our existing legal systems or existing legal norms. There are many issues are also cropping with reference to this drone technology or with reference to use of drone technology in India. Presently, it has been, it has been banned for use of private without a proper, the process and procedure and, compliances. But you will find that in coming time, you will find, and one of the important, research which we were conducting in our School of Law, that new important other disciplines knowledge base can also be utilized for bringing out the new solution in the legal domain. Earlier, we have seen, the social engineering, one of the important facets of, how law is growing in the society, we have seen. Now there is new emerging, era as well, where we have to say, and we are seeing, and we are working continuously. Entire world is working continuously. Entire, India is working continuously, where we have to say that now crime engineering, cyber crime engineering has to also happen. How it will happen? How it will happen? It will happen based on, understanding the modus operandi of the engineering field. Understanding, the modus operandi, data, theories, principles, background of the engineering. Now we have recently seen that in cyberspace continuously, many offenses, cyber crimes against children, women, continuously it is happening. Crime Control Bureau of India has not given, up-to-date, statistic on their website presently. 2020 data, it has not come on their website currently. But if you will see carefully backdated data, you will find that how cyber crimes against children, against women is also continuously happening. So to resolve those important issues, we have to also bring the new analogy. We have used those new analogy from other discipline to prevent the environment pollution. We have brought that, engineering principle to prevent the pollution. We have brought that, precautionary principle, polluter pays principle, one of the important facets of, the engineering field or environmental engineering we have infused in our, legislations. We have infused at the international level by way of Rio Declaration on Environment and Development, where specifically Principle 15, Principle 16 recognize those, environmental engineering based principles, where precaution that has to be taken at the beginning of the pipe, that particular approach reflected in our, environment conservation and protection legislations? Can we also infuse the similar analogy in our criminal justice administration or in our criminal laws? That is also very much possible. That is also very much, possible for the legal system or for the legal researcher. That continuously we are seeing that the criminal law is ultimately based on preventive approach. Criminal law, or even you can take into consideration, the cyber law as well, it is continuously based on, we can say preventive approach. The criminal laws, criminal legislations are based on ultimately, on preventive approach. Means the system or the authorities or the law enforcement agencies, they will take the cognizance after the commission of the crime. After the commission of the crime. From environmental legislation, from environmental engineering, we have seen the approach from environmental engineering, it had been carved out and it had been infused in pollution legislation or pollution prevention legislation with the help of precautionary approach. So we have to also think that can this precautionary approach can also become inbuilt mechanism to deal with these cyber crimes or to deal with, these crimes which are continuously happening against the women or against the children. Because there is no precautionary approach infused in the criminal justice administration. The system is continuously, working, aftermath of commission of crimes. But to your surprise, many plans, many policies that is being carried out by many states, many governments to prevent the crime. But for prevention of crime or, precautionary measures or precautionary approaches, the Home Ministry of India or Home Ministry of other countries, what kind of precautionary measures, plans, policies are being infused in the criminal justice or we can say criminal legislation. That is also yet another important area to explore from the window of interdisciplinarity. You'll surprised to know that when 15 to 20, ruffians or, these destitute children, youth, they were taunting, giving certain remarks against women, passerby on the road. So those, 15 to 20, those destitute youth, those were brought in the police station. This is the instance of the Delhi I am talking about. And especially, one sent, one from the temple, he has been invited. One Panditji from, one temple, he has been invited. One, father from church, he had been invited. One, Maulvi from, mosque, he had been invited. So all from all religions, they were invited in the police station. And police authority, they requested that provide them, counseling. And they started giving the counseling to those all 15, 20, destitute youth who are taunting to the women, who are, making certain remarks or indecent remarks against women when they were, passing from the roads. And after that particular counseling, they were, left, and they were, made free to go to their, the respective places. So this approach, indeed, at the bottom line, that is required. That pyramid theory, that is the engineering model that we have to also work upon in our criminal justice administration or in our criminal legislation. that pyramid theory of engineering department, or we can say engineering discipline, that has to be also carefully understand to bring out the new solution in our criminal justice administration. In pyramid theory, at the bottom of that pyramid, you will find that there are small deviations. And those deviations are taking, a grave form at the top. So those small deviation at the ground level, that can be eradicated with the help of precautionary approach in criminal justice and criminal laws and legislations. So the analogy of engineering, analogy of the cyber engineering, that can also be used in criminal justice administration. This drone technology, this face recognition, this CCTV, these all, we can say information and communication technology, that can also be carefully used and utilized in criminal justice and criminal legislations to have this precautionary approach to, prevent the crimes. So that is yet another important domain we have to also understand, and we have to also explore when we are talking in the context of interdisciplinary approach and interdisciplinarity. Interdisciplinary approach and interdisciplinarity is also yet another important domain which is going to provide the new solutions to the complex legal issues. Now, when we are talking in the context of, further, like law and education, law and artificial intelligence, we are seeing how, education is also getting influence. Or how we can say that the law is also getting influence with the help of technology, with the help of, we can say this information and communication technology. You'll surprised to know that down the line in coming 20 years, there will not be any university in existence. I am telling you, you can mark my words. Down the line in 20 years, there will not be any physical infrastructure as a university. Process already started. National Education Policy 2020, that had already given the way forward. But you will surprised to know this. We are continuously seeing that how education is also getting transformed with the help of technology. Or how even, rules, regulations, which is regulating the education, that is also getting influenced with the help of emerging technology. There will not be any university, there will not be any table, there will not be any chair, there will not be any room, there will not be any building, there will not be any kind of, we can say physical infrastructure down the line in coming 20 years. Whatever legislation which will be passed from the side of state or from the side of central government to establish any university, that will be based on a strong, ICT and information and communication technology. And that would be based on, more specifically one satellite in the air and space that will work, based on, cloud computing, and more specifically, generation of data of that particular university. Each student, each teacher will be working virtually. Research obviously started, happening virtually. So we have to also explore the new important avenues. And we will also be confronting with a new complex legal issues to resolve those new, emerging issues with which we are going to, confront with. Why I am saying this? Down the line, if you will see carefully, analyze carefully this national education policy, its vision, mission, it is also, taking towards, more specifically this information and communication technology and use of information and communication technology use of, these online resources, use of this, online blended learning, use of this, more specifically, this virtual learning, teaching, learning process. So education is also going to get transformed with the help of technology, and accordingly, the new legal solutions and new legal research and new important, new recommendations, suggestions, new problem solutions that has to be also looked into, from other disciplines knowledge base. Many jurists, many academicians, they are little worried as well that in this interdisciplinarity, in this interdisciplinary approach, that expertise in a particular domain, it is getting diluted. That is some or the other way. The doubt that is also being created, that is also being, expressed by many academicians. But now we have seen continuously, and we have been continuously seeing that law is growing based on, continuously these, different experiences from different disciplines. Now entire, this world has become the global village. The person sitting, 12,000 miles away is interacting, face to face today with me or with you. So those barriers, those, boundary, those, we can say mechanical, technical barriers, nowhere. And those have been, totally blurred now. So totally a new, world is getting shaped, where you are continuously finding that new issues are also cropping. So in that context, this particular worry which has been expressed from the side of, many academicians, some or the other way, where expertise in this interdisciplinarity is getting diluted. But now this is the age where, this expert knowledge of a particular discipline is also required to have, this supplement or we can say the supplementary backup, from other disciplines. Because you cannot, resolve the dispute, excuse me, or the Supreme Court of India or the judge cannot resolve the disputes where, these technological nuances are involved unless and until he will not have that particular, the knowledge base, or if he or she will not, have or explore that particular knowledge base. Similarly, when, now we are also continuously seeing that how this artificial intelligence is also going to impact, more specifically, even the decision making, even the judicial setup of the country. Process already started. In many European countries, many Western countries, Oregon University continuously working upon, that face recognition software inside the, courtroom management, or speech recognition software in the decision making, which is being used for, speedy justice administration. Similar analogy is also going to come in our Indian legal system, in our trial courts, process and procedure. So expert knowledge of decision making or expert knowledge of law has to be supplemented, has to be blended with other disciplines knowledge that is very much required now in 21st century. When question comes with reference to law, economics, technology, we were and we are working with the help of this external funding and internal funding in the context of from our university and from other organization on very important project that is in the context of an economic analysis of this judicial process, economic analysis of lawmaking process. economic analysis of law-making process in the context of this information and communication technology. So see, three disciplines at the same time I am talking about to bring out the new solution. Economic analysis of law-making process with reference to evolving information and communication technology. So researcher, as a teacher, as a researcher, we have to also understand and we have to also find out the new doctrines, new principle, new ideas, new statistic which is available in other disciplines and how we can bring the new solutions for legal research. So in this particular project, economic analysis of law-making process with reference to information and communication technology, we have completed 30% work so far, but it is long project and time-taking project. You will surprise to know this present day, after this aftermath of this COVID-19, or we can say this after this COVID-19, entire world is confronting with this economic recession. We have seen somewhere many continents, including our adjacent neighboring countries as well, including Sri Lanka, Pakistan, Bangladesh, other continent, African continent, European continent, Western countries as well. We are continuously seeing aftermath of this COVID-19 economic recession has become one of the basic or one of the big issue with which the entire world is confronting with, and India is also not away from that. So we have to also find out the new solutions. It is not always necessary through legal research or through your research. There will always be existence of problem or difficulty in your research. You have to find out the new solutions to tackle, coming difficulties as well, or coming problems as well in the society. To your surprise, you will come to know that to some or the other way, for augmentation of exchequer of the entire country, or we can say exchequer of the consolidated fund of our country, we have brought, one simple analogy of economic analysis of lawmaking process, where the entire world is going virtually. The lawmaking process during COVID-19, it was also happening virtually. So that analogy we have taken into account to tackle with this, economic recession, or for augmentation of our exchequer of the country or consolidated fund of the country. We have seen United Kingdom, during COVID-19, 22nd April 2020, they were working, first time online for, lawmaking process. Chile, they had changed their constitution. The country Chile, I'm talking about, they changed their constitution and brought the amendment to, have the online parliament or online lawmaking process. Switzerland, many European countries, they have, conducted their online process for lawmaking process and procedure. Even justice administration, we have seen continuously it was happening with the help of virtual hearing. So this much sensitive issue, just like justice administration, when it can happen virtually, or recording of the evidences or cross-examination of evidences, when it can happen in sensitive matters virtually, then question comes, or the argument comes, or the legal argument comes, then why then lawmaking process should not happen virtually? Not replacing the entire physical lawmaking process, but at least certain segment of that 1 month session of lawmaking process, at least 7 days, that can happen virtually, where all parliamentary members, they can sit in their constituency, in their house and their constituency, understanding their problems, and they can directly connect with the speaker of Lok Sabha and Rajya Sabha virtually. They can put their questions, they can put their question hour virtually. You will surprised to know that in this entire country, almost 5,000 and odd legislative members, including parliamentary members, they are working. daily 5 lakh questions, those are being asked, through the paperwork in the parliament or in different legislative assemblies. You will surprised to know that there is, huge, paperwork. It is also happening, during or in this particular process. But we are not saying to replace this lawmaking process based on economic analysis. We are not saying that it should be replaced in a totally virtual mode. But new ways is also possible, which is more and more economic based or economy based. You will surprised to know that through this particular, the project which is based on economy, lawmaking process, and information and communication technology utilization, which is using these 3 different disciplines knowledge base, you will surprised to know that when we had filed and we received the information from the legislative department of, our government of India, we received the information, and in that we came to know, based on the data which has been provided, that for conducting this one-day session, that is 7-hour session, 8-hour session of parliament, there is cost of 20 crore rupees per minute. It is the cost of 4 to 5 lakh rupees, inclusive of the salary of those parliamentary member, their telephonic, the allowances, their, conveyance allowances, their residential allowances, their, commutation allowances, their airfare allowances, their, mobile phone allowances, their, food subsidy allowances. You will find that we came to know, based on the data, that per minute session, for conduction of per minute session, the cost of that per minute session, conduction of session, is 4 to 5 lakh rupees. That is the economic analysis with which we had, seen that interface of information and communication technology based on economic analysis of this lawmaking process. It can also run through, information and communication technology. Not replacing, this our democratic process. But it is very much possible, because we have seen that entire cabinets during this COVID-19 was working virtually. The president of the Russia was interacting with our Honorable Prime Minister, Narendra Modi, virtually, for decision making, for certain policy making, with reference to certain vaccines and vaccinations, with reference to, exchange of certain vaccinations. The cabinets was also working, virtually. During COVID-19, we have also seen that how justice administration, with the help of SOP, that is standard operating procedure, which had been brought immediately on 23rd March 2020 from the side of Supreme Court of India, to have the virtual hearing. So if you do carefully economic analysis of lawmaking process, you will come to know that, for a certain segment of time, this, lawmaking process, it can also be run through or with the help of information and communication technology, which can augment the exchequer of the country, which can provide the impetus to the exchequer of the country, which can provide the impetus to the consolidated fund of the country, and that particular, the amount of money can also be diverted to the other important, segment of the development. It is very much possible, because the entire world is working now. You will surprised to know that the World Parliament is working every year, where India itself is the party. India itself is sending the delegation in this World Parliament, World E-Parliament conferences. What is ultimately object of this World E-Parliament conferences, which is taking place under the aegis of United Nations organization every year? Ultimately, object is that to find out the new ways and where, we can bring this digitalization and bring this, information and communication technology and its more and more use and utilization in this lawmaking process. That is ultimately the object of this World E-Parliament, which is happening every year. It is not something new which we are talking about through our research work, or to find out the new solutions, to bring out the new solutions to the existing legal system. It is already happening, but one step ahead we are also talking about. Because this particular model where, strong firewall system based information and communication technology, and that particular product, it can be devised with the help of, these computer engineers, with the help of information and communication technology. And that can be installed, that can be brought into the process of lawmaking. And it is based on economic analysis. It is based on cost-benefit analysis. It is based on the interface of law, technology, information technology, economic analysis, and lawmaking process, public administration. We are also continuously, tackling, no doubt, with this pendency of cases, and continuously, Ministry of Law and Justice, they are also working. You must have seen and observed how exactly this, the new project to bring out, the new solutions to tackle with this pendency of cases that is being brought, new solution that is being proposed. But in this entire process as well, the interface of this information and communication technology, interface of this artificial intelligence, which is very, very meagerly used by our Indian legal system, unlike European countries, unlike, United States of America, unlike, Oregon, or more specifically, European countries, they are continuously working, excuse me, that how, courtroom management can also be based on artificial intelligence, so that, case disposal rates can be more and more in a speedier manner. So the use of artificial intelligence, including speech recognition software, where now, we are not talking about to replace this, existing, manual, or existing, manual laborers, or existing, man powers, or man forces. We are not talking about that. We are talking about that if in courtroom management, this face recognition, based artificial intelligence, more specifically speech recognition based software, artificial intelligence based information and communication technology for document, recording, or cross examination, or more specifically chief examination recording, speech recognition software, if it can be utilized for processing the documents of this, entire court process, if it will be utilized, then automatically this process of, time-taking process of, huge document verification, huge document recording, that will be lessened with the help of artificial intelligence. That can also be used and utilized. Those new solutions can also be proposed with the help of, this new legal research, where criminal justice administration based, research is being conducted by many research scholars in the entire country. Now, when we are talking in the context of law, media, and entertainment industry, you will also surprised to know that how this Hollywood industry, Bollywood industry, it is also impacting, our, rules, regulations, or more specifically, you will surprised to know that this Hollywood industry, Bollywood industry, or we can say this film industry, is also having, million crore rupees, the business. And you will surprised to know that every day, there are different legal compliances different complex legal issues are also cropping up, where nuances from this discipline or nuances from other discipline that is also required for bringing out the new solutions. Let me tell you here more specifically with the help of certain examples. Every film producer, he required to have certain legal compliances. If he shoot particular or doing any kind of, shooting in particular area, he has to, perform, he has to have, certain important permission from the district magistrate. He has to have certain permission from the, more specifically, the superintendent of police. Or he has to provide a certain information with reference to that particular process of his or her, film shooting. Not only that, you will find that in this entertainment industry, more specifically, film industry or media industry, you will find that there is, different transaction right from, film production transaction, film production contract, music contract, more specifically, artist performers contract, those different contracts and agreements has to take place. Even, censorship related, issues as well we have seen, like in Padmavat movie and many more other movies, when it had gone in front of, censor board and it had come before the Supreme Court of India, the nuances with reference to filmmaking, nuances with reference to or the knowledge or the doctrine or the principle or the idea with reference to this film industry, filmmaking, that is also required to provide a new, we can say, the solutions to resolve these complex issues. So here, what exactly I am saying, that when we are talking in the context of, this interdisciplinarity, especially in legal research, for doing the legal research, for conduction of legal research, you have to have the analogy of other disciplines. You have to, work upon the analogy of other disciplines. You have to, bring out those tools, techniques, those doctrines, those principles. You have to connect, synthesize those principles, those doctrines, those ideas of other disciplines to bring out the new solution. Student from Jodhpur National Law University, one of the best example. And here I would like to also, attract your intention, how new advocacy based on interdisciplinary approach is also going to grow now. But let me give you first the very important example which has come from the side of Supreme Court of India, which has come in the case of Swapnil Tripathi versus Supreme Court of India. This is the case first time after Subhash Agrawal case. This is the case against Supreme Court of India, which is filed by one of the law students from Jodhpur National Law University, where, in the background of this more and more crowd in the Supreme Court, certain entry of the student or, certain entries that had been restricted in the Supreme Court of India on a particular day, like, when there are new, admission cases on the Monday that had been restricted. So in that background, this particular litigation petition that had been filed from the side of Swapnil Tripathi before the Supreme Court of India, saying that right to education and right to legal education, that is totally being abridged because of this particular circular of Supreme Court of India, restricting, the entries of the student, where student now they cannot know and they cannot learn and they cannot get educated and they cannot see the proceeding live inside the Supreme Court. So in that background, this Swapnil Tripathi, indeed, he had contended before the Supreme Court of India or his advocate had contended before the Supreme Court of India that Supreme Court proceeding that should be shown live to the people of the country, and that should be shown live to the each and every student of the country with the help of this information and communication technology, with the help of this ICT, with the help of this information and communication technology. And you will surprised to know that Supreme Court of India, and especially Justice Chandrachud, as one of the judges on this particular bench, he had given very, very important, the opinion and important legal propositions. And he has given, very, very categoric, guideline to Ministry of Broadcasting and Ministry of IT, that at least constitutional bench judgment that should be shown through live streaming to the entire country. At least, national importance subject matter that should be shown live to the entire country. This is the guideline that had come from the side of Supreme Court, and that had been given from the side of Supreme Court, more specifically, to the Ministry of, Information and Technology, Ministry of Broadcasting. But you will come to know that the background, the rationale, the important analogy which has been used from the side of Supreme Court while giving these particular guidelines, that is very, very important to understand. That rationale is very, very important to understand. Supreme Court itself had stated that, justice administration, to repose the faith of the people, that justice administration, that should not only be done, but it should be seen to be done. To make this entire country and entire country's people as informed citizens, it is also required to see, it is also required for them to see their, justice administration, how exactly it is happening, which is happening, in time immemorial in our country, from ancient time in an open court system in our country. So the same thing, same analogy, same important, platform that should also be made available to the public at large with the help of live streaming to the public, live streaming to the student, live streaming to the each and every segment of the society where the subject matter of the national importance or subject matter with reference to constitutional interpretation, if it is happening inside the Supreme Court. So see how beautifully Supreme Court of India itself is saying that facilitation of or access to justice, it will happen, if citizens, they will become informed citizenry. And, this justice administration, if it will be shown to them, live, just like Lok Sabha channel or Rajya Sabha channel, let the justice administration should also be seen or should also be watched by the public at large, through this live stream. With the help of this now new similar analogy, now new important, the discourse, new important, the solutions, or new important, we can say, the way forwards are also possible. So far, no one has argued in front of Supreme Court on a particular issue which I am going to tell you with reference to interdisciplinarity. We have traveled, we have seen access to justice, to provide access to justice, to provide free legal aid, to provide dignified life, right to life, free, speedy justice, legal aid, which is one of the important facets of our Indian Constitution. But with reference to this particular facet, how Supreme Court interpretation time to time got changed. And it was made to change. We have seen like Akhil Bharatiya Soshit Karmachari Sangh versus Union of India, 1985 case. Justice P.N. Bhagwati totally revamped this very basic idea of, locus standi based on, enforcement right, or Article 32 in front of Supreme Court of India. Till, Judges Transfer Case 1982 or this Akhil Bharatiya Soshit Karmachari Sangh of 1985, till these cases came before the court, before these cases, we have seen how rigid approach for enforcement of fundamental rights, human rights, that had been used from the side of Supreme Court in the context of Article 32 of our Indian Constitution. I am taking you towards the new analogy with reference to interdisciplinarity, with reference to information and communication technology utilization in access to justice. Just please listen carefully. Before ABSK Sangha case or before Judges Transfer case, the premise or interpretation of Supreme Court, or we can say the legal research or the established law, it was limited. And it was only saying that the person whose right violated, he should only approach before the Supreme Court. That was the rigid approach. He is only having locus standi. That was the approach. And that was the interpretation. But that interpretation got set back or shattered with the opinion of Justice P.N. Bhagwati, where very, very tactfully, very categorically had brought this particular analogy where Article 32 is not defining any adversarial system. It is not giving any process and procedure how to approach before the Supreme Court. It is only saying the constitutional remedy by way of, issuance of certain writs that can happen for the enforcement of fundamental right. And this rigid approach of locus standi is bringing certain hardship to those poor people of the country. It is bringing hardship to those people who are ignorant, who are not aware about their rights. They are not able to approach before the Supreme Court, even if they are having the right. So what is the use of this interpretation of locus standi? The person whose right violated, that can or that could only or that can only approach before the Supreme Court. Because the major segment of the society, they are economically at disadvantaged position. They are unaware about their, rights. They are not having the means and mechanism to approach before the Supreme Court for the enforcement of their fundamental right. Even if they are leading their life in the environmental pollution, even if they are, getting deprived because of their, dignified life, but they are not aware about their rights. And even if they are aware about their rights, they are not having means, mechanism or economic, strength to approach before the Supreme Court. So how come we can say that this is a real protection of fundamental right? So this particular rigid approach that should be revamped with a liberal approach to approach before the Supreme Court of India. So any public spirited person can also approach on behalf of those poor people for championing their cause. So till here we have reached. Till here we have reached for access to justice to the downtrodden people or the last person of the society. And accordingly, we have seen the law got established and it is continuously working. But now from here onward, in 2022 onward as well, we are saying that new interpretation for access to justice is also going to occur based on this liberal approach, which can also get more extended with the help of emerging information and communication technology. The access to justice, we have seen even the later petition which had been adopted, accepted by the Supreme Court of India, which is addressed to any judge or any secretary, any registrar of the Supreme Court of India. If there is problem, particular person is addressing that through the letter, that has to be, given the docket number, and that has to be admitted for the hearing if there is, any particular genuine issue of the public. So similarly, with the help of, now this evolving information and communication technology, now I am saying that access to justice can also happen with the help of video petition. And that should happen with the help of video petition. And the person, the last person of the society who is sitting in that Kerala district or any particular, remote village where, small internet facilities available, that he or she can record his grievance with the help of, video petition, and he can directly file, before the Supreme Court of India with the help of this liberal approach of locus standi, with the help of, this evolving information and communication technology. And it is very much possible. The Supreme Court of India itself has, shown this particular concern, but, many experts from Bar Council of India or many experts from, the legal domain, they had denied that how exactly virtual hearing should be in continuation, because there are many nitty-gritty with reference to virtual hearing, and that should not be in continuation. But virtual hearing with the help of information and communication technology can be claimed as a human right of the citizens of the country in the background of, Fahima Shirin versus State of Kerala, while access to justice with the help of video petition before the Supreme Court of India can be asked as a matter of human right, can be asked as a matter of access to justice, can be asked as a matter of right to life, can be asked as a matter of dignified life. Because why I am saying this, that Fahima Shirin, this legal proposition of this particular case is showing the way forward, where it has been acknowledged, accepted that access to internet is one of the important facets of human right, one of the important facets of dignified life, one of the important facets of right to education, one of the important facets of right to information, one of the important facets of right to know and right to information. So taking this analogy, taking the analogy of evolving information and communication technology, even, this ABSK Sangha case, Akhil Bharatiya Soshit Karmachari Sangha versus Union of India, which is the established law till today, that can also be extended, saying that access to justice, that should be extended, that should be extended within the interpretation of locus standi, that Article 32, and under Article 32, this video petition as one of the important facets of enforcement of fundamental right that can be claimed as fundamental right to access the internet or access through internet. And that is very much possible, because literature is growing. Literature is, supporting. The literature from humanity, literature from human rights discourse, literature from international relations is supporting this particular, legal proposition. The international legal instrument itself is saying that human right can be accessed by each and any means and mechanism. So any means and mechanisms, even through this internet, which has also been recognized as a part and parcel of human right. So this particular analogy, Akhil Bharatiya Soshit Karmachari Sangha, P.N. Bhagwati, Justice P.N. Bhagwati's analogy, Anuradha Bhasin versus Union of India, that access to internet as one of the important facets of right to know, right to information, right to dignified life, that particular analogy. Swapnil Tripathi versus Supreme Court of India and others, 2018, where the analogy which is saying that access to internet, that should be facilitated or access to justice that should be facilitated with the help of this virtual hearing, this particular analogy is going to bring a totally a new rights for the people of the country. And that is very much possible. That is very much possible with the help of, this interdisciplinary approach, where we will be using the different tools, techniques, doctrines, principles, knowledge of other disciplines to connect and to blend to bring out a new way forward. Now, when we are talking and going ahead in the context, I'm so sorry, my slide will not move anywhere, because slides are certain important points only in slide. So don't feel that why slide is not, moving forward. It will move to certain other discussion point. So going ahead, let me also tell at this juncture, when we are talking in the context of how other disciplines knowledge base can also bring a new solution or a novel solution in the legal research. So when we are talking in the context of law and psychology, law and humanities, let me tell you, in India, research already started, but to very in a small quantum it has started. But European countries, Oregon University, Western country, United States of America, we can say research continuously growing with the help of even the psychology or even the psychology domain or discipline. To your surprise, let me provide this particular the example that the research which is also happening based on the mental status of the judges, how it is influencing the decision making. No doubt, Benjamin Cardozo in small book in his judicial process, he had given very tactfully, very categorically in small book, very strong opinion he had provided already, that while decision making in judicial process, judges, their antecedent, their history, their family background, their economy, their poverty status, their wealth or wealth status, their richness, poorness, that also impact and influence the decision making. Benjamin Cardozo already propounded this particular aspect. But when we are talking in the context of legal research and we are seeing this psychology, or when we are seeing this, philosophy, psychology, the psychology of each and every judge also influence the decision making. In Oregon University, this research happened on, 100 judges, where, some judges, they were, coming from poor status, some judges, they were coming only based on their poverty status or their, status of social status, or their wealth, or their background or family background. So just based on this component, these factors, they conducted the research. They conducted the research based on the decision making of those 100 judges. They conducted the research based on their psychology, based on their family background, based on their we can say the societal background. So they have observed that the 100 out of 100 judges, the judges who are coming from humble family, or judges who are coming from poor strata, their the final orders in different trial courts, or their the orders in the trial courts or final orders of trial courts, the behavior of those orders were totally different as compared to those other judges who are from rich strata of the society. the rich strata of the society. That was only one component that had been taken into account while, researching and bringing out certain important, finding. It is not foolproof, we can say the all component based research, but only one component based research, it had been conducted. And where they have observed that the judges who are coming from, rich strata of the society, their final judgment were more strict. There were more conviction rate. There were more, we can say the conviction rate, or more and more, sentencing, or more and more, harsh sentencing in majority of cases they have observed. But the judges who are coming from, the poor strata, or through some struggle, they reach to the court, or they, hold the office of, judicial office. So they observed that, or through this research, it had been observed that those judges, the final orders, more and more it were inclining towards, less and less conviction rate, lesser and lesser, the quantum of punishment or quantum of sentencing. So this was only one factor from the sociological background, from the psychological background, from the family antecedent, from the past history of the judges that had been used to, find out the reality in the decision making or the law making process. So that is also possible. That is also possible in our country, in India, that the domain, that from the other domain research work or the findings, you can also infuse in our legal research. You can also infuse in our legal, the domain to bring out the new solutions. For your surprise, you will also, and you must have already read Professor G.S. Bajpayee's, research in criminal justice and sentencing. And I think he's continuously working on that particular project presently as well. But in his preliminary research, you will surprised to know, he has brought a particular guideline, quantum process in criminal justice administration just based on the sentencing, where, minor offenses or where, compoundable offenses, where 3-year punishments are prescribed, including, certain, simple hurt or certain, trivial offenses where 3 years punishments are prescribed. He specifically observed that, and he had taken the cognizance of, 4 or 5 different states and trial court cases, finally adjudicated, trial court cases. He found that in a similar nature of offense of, state of Rajasthan, or trial court of state of Rajasthan, trial court of UP, trial court of Maharashtra, in similar offense, similar nature of offenses, similar nature of, mitigating, aggravating factors, similar nature of, the circumstances, those different state trial courts judges, they have recorded different quantum of punishment. Some judges, they recorded 2 years punishment. Some judges, they recorded 5 months punishment. Some judges, they have, given scot-free to that, particular, alleged person. Some judges, only imposed the fines and, given a meager, punishment. So in similar nature of offense, similar circumstances, similar aggravating and mitigating factor, but different quantum of, punishment, different quantum of, fines. So this research had also been conducted to bring out a certain model where a minimum, a guideline that can be followed or that can be followed by the trial court judges. And that work has been done from the side of Professor G.S. Bajpayee, presently the Vice Chancellor of Patiala National Law University. And I am very much influenced by his work as well, especially in this public law domain, where quantitative measures, where statistics, that is also being used to bring out the new solutions, to bring out the new ways to think, to bring out the new, augmentation of legal knowledge. Because legal research is not always only to solve the problem. It is also to add to the new value addition to the existing knowledge base with the help of other disciplines' knowledge. So that is possible with the help of, other disciplines, tools, techniques, knowledge, doctrines, principles, ideas. And we have to always keep open our eyes and mind to take and imbibe in our research process. Now, legal education, and there is continuous, this landscape of legal education and legal research is changing because of, many factors. We have already seen that. The fast growing, socio-economic development, liberalization, globalization, we have seen emerging complex issue, now new idea of global citizens, which is also coming, expanding utilization of many software in various activities we are continuously seeing. So legal education, landscape of legal education, it is also continuously changing and getting changed. It has to imbibe. The legal research, legal education has to imbibe the new ways, new thoughts, new modus operandi, new ways, new domain it has to also explore. As we have already seen that liberalization, globalization, it is directly impacting the free trade, economic development as one of the important facets or the agenda of, the country. It is also continuously, working upon. So new policies that has to be also properly carved out. You'll surprised to know, if you will carefully analyze the 2014 till 2014, the successive government policies, legal policies and laws. This can also become one of the important best research, one of the important strong research base for value addition in the legal research based on the interdisciplinary approach. If you will carefully analyze the plans, policies, laws, rules, regulations which were facilitating the economic development from the side of successive governments till 2014, I'm not naming any particular political parties here, but successive government till 2014, their plans, their policies, their laws, it was some or the other way, not more and more inclining towards economic development. And I'll give you the example based on the documentary evidences. If you will come to know that many important environmental clearances, 2014, I am talking about, before the advent or before the inception of the new successive government, which is present, currently working upon in the country. If you will analyze the policy, if you will analyze the environmental legislation, if you will analyze the environmental clearances for different, companies, corporations, different, mining industries, and different clearances for mining industries, those were pending before the Ministry of, Forest and Climate Change, Ministry of Environment, Forest and Climate Change. Huge number of pendency of clearances were there before the Ministry of Environment and Climate Change. The central environment impact assessment agencies, they were flooded and they were, they were flooded with many environmental clearances. But those were pending before the then government with their policies. If you will see carefully, after advent of new successive government 2014, new important policy that had been ingrained in different plans, policies and laws and rules and regulations, including Environment Protection Act, including Mines and Minerals Act, including Environment Clearance Process under Environment Impact Assessment Notification 2016, it got changed. to provide more and more impetus for the foreign direct investment, to provide more and more impetus for the investment from the companies, corporations working in this mining industries and asking for environmental clearances. Mines and minerals, legislation, those were also amended with the new provisions which can facilitate, this foreign direct investment and which can facilitate, this fast track environmental clearances. Fast track environmental clearances process, one window clearance process that had been brought as a norm in environmental policy, as a norm, more specifically in environmental legislation, changing, environment impact assessment notification originally, which had come in 2016. Originally, which had come in, 1996, amended in 2006, and then, more specifically 2010, and then in present government regime in 2016. So that new approach of economic development, which is percolating through plans, policies, laws, rules, regulations, that has to be also tactfully, carefully, that has to be also understood to bring out, the new solutions and to understand this changing landscape of, this legal education. I'm not going, in this, particular area more further. We have already discussed that what exactly is the contours of, interdisciplinary research, what exactly is ultimately foundation for legal research. So in a simple sense, we have already seen that interdisciplinary research is the study or research which draws from two or more discipline or other different disciplines, certain important, we can say the analogy, certain important, we can say the wisdom to gain more well-developed perspective to discover something new. The same thing we were discussing about. That interdisciplinary research is nothing but to bring out the new solution, to bring out the new ways to think, to bring out the new, tools, techniques. Because we cannot deal with these complex legal issues of this cyberspace, or we cannot deal with this, this digital medicine or medical jurisprudence, which are more and more complex. Now this robotics, which is also, entering in this, our, legal domain, or even, recent, more specifically this recent data protection bill, which had been withdrawn recently with the commitment from the side of, successive governments saying that a comprehensive legislation will come. Here as well, we required to have the wisdom from information and communication technology to understand what exactly is internet intermediary, what exactly is, more specifically the first originator of the WhatsApp message, who is ultimately, internet service provider. So who is ultimately is regulating this entire, information and communication technology or internet or the cyberspace. So that knowledge base is very much important to resolve those important issues or complex legal issues. Solutions to the increasing problems in different domains, like, very few research is happening in our country, but some people, they are conducting that best to best model of many European countries is being, examined presently to reduce the number of road accidents. Now, solutions to this increasing accident number, that can also bring out with the help of other disciplines knowledge base. Like our policy can get changed based on, other engineering or computer engineering or information technology based, the tools, techniques that can be used, or robotics, or more specifically information technology based, tools, techniques that can be used in a policy framing. Many countries, many European countries, including Switzerland, I am saying here that they are using totally this information and communication technology to regulate this traffic system. Their traffic system is totally regulated with the help of drone technology, totally regulated with the help of CCTV, totally regulated with, automatic signal system, totally regulated with this, virtual system. Even, there is no, crowd on a particular signal. One signal on one particular signal in traffic road, is totally connected automatically with other signal which is situated 10 kilometers away from that first signal. Even they have used this drone technology to keep a proper monitoring on this road traffic system. So policy or this traffic law or our this Indian traffic regulations, that has to be also grown based on the new wisdom of other disciplines. So we have to think accordingly. We have to find out the solutions accordingly. Big data, business, human rights, privacy rights, continuously growing. Big data we are talking about. Cloud computing we are talking about. Now we are playing. We are playing in the data, playing with the data. Because daily every person is generating the data. You will find and you will surprise to know the number. Every city, every town, every city, every town is generating in a million bytes of data or kilobytes of data. Where exactly it is going? It is going in a private server presently. It is going, in the Google server presently. It is going in the WhatsApp server presently. It is going, in the LinkedIn server presently. It is going in, everywhere. So country is also not having that particular robust data protection and that particular independent server regulated by the government of India or regulated by the country. So privacy right, definitely it will also occur. And as I was discussing, that in coming time, there will not be down the line 20 years, this physically the university in presence. Just like I am sitting in the GD Goenka University in physical infrastructure, or you are sitting in this Asian Law College with physical infrastructure, that will know where it will be in presence. We will work in big data, cloud computing server that will be there, installed in the cyberspace. There will be somewhere in air and space. Our entire data, it will be stored there. Our this lecture, it will be stored there. Our these video clips will be stored there. Our every academic process, it will be conducted with the help of the cyberspace, air and space, with the help of information and communication technology. So many human rights issues, those are also going to crop up. So we have to keep our minds and eyes open to tackle with the help of other disciplines knowledge. New legal challenges, complexities, and new solutions for those problems are present in other disciplines. And we have to, take into account other disciplines' knowledge base. As I was discussing in the beginning, that economic recession amid COVID-19, that can be tackled very systematically with viable solutions in public administration and lawmaking process based on its cost-benefit analysis with the help of information and communication technology. And we have seen cost-benefit analysis, how, one day session of parliament, it is, incurring almost 20 crore rupees. And if somewhere, someday, our parliamentary member, they are, raising the chairs on each other, we are seeing that how those 20 crore rupees are going west for that particular day. So virtual hearing, as a human right, we can also claim in coming time. Virtual parliament, as a human right, we can also claim in coming time. the new way to augment our exchequer of the country, we can, ask to the government of India in coming time as a matter of human right. And that is very much possible. Economic analysis of criminal law and sentencing, that is also very, very important, because we are continuously seeing that in minor, meager, trivial offenses, people, they are also lying behind the bar. Non-serious offenses, the people are also lying behind the bar. And it is overburdening on the exchequer of the state. Increment of, their expenses, their food expenses, their safety, security, protection expenses, that is happening from the side of state. So if economic analysis will happen of those compoundable offenses systematically based on the data of Crime Control Bureau of India or based on the data of different states, a new ways of restorative justice, new ways of, the justice administration based on economic analysis, those non-serious offenses, jail inmates, they can be scot-free, they can be, freed in the society. So that the overburdening the exchequer of this, jail administration, that can be properly tackled. So you can also find out that how economic analysis can give the new ways in criminal justice administration and sentencing process. Adaptation of artificial intelligence in criminal cases and civil cases trials. This is also possibility to tackle with the issue of justice administration. Very slowly in India, it is happening presently. Presently, in trial court, justice administration, very slowly this process is happening. But artificial intelligence and its adaptation will give the new ways for speedier justice system in criminal subject matter, civil subject matter. Speech recognition software, as I was discussing, face recognition software, I was discussing data processing, software, as I was discussing, digitalization of, process which has already started in criminal justice administration in trial courts, but that is not sufficient presently to tackle with this issue of delay in justice administration. So robust use of artificial intelligence and that task force and that, robust force in courtroom management, that is also required. And that policy process that has to be also, carved out by the legal researcher in the coming time. Mental and psychological health influence the decision making of judges, as I was discussing earlier, this particular point, that psychological health also influence the decision making of the judges. This research can also give the new ways to the policymaker, to recruiters, to the judges, or we can say in the process of justice administration. That mental and psychological health, very few research in India that has happened. Mental and psychological health of the judges also is important in the decision making process, or to tackle with this delay in justice administration. But no research is being, conducted on this particular aspect. Hazardous activities to human lives in industrial areas. Application of science and technological growth, wisdom for resolution of problems. Hazardous activities to human lives in industrial areas, and we have seen how for these hazardous activities, in industrial areas, we have also brought, certain application of science and technological growth, wisdom to resolve those problems. We have seen, more specifically, hazardous substances management and handling rules under Environment Protection Act, we have brought into existence. We have brought into existence this environmental engineering principle to tackle with this pollution or rising pollution because of these industrial activities. And that was possible after understanding the scientific, after understanding the environmental engineering, after understanding the science, after understanding the scientific knowledge base, those important inputs, those were carved out in the existing rules and regulations. If you pick up those, important, hazardous activities related rules and regulation, it is giving the interface of scientific knowledge. It is giving the interface of technological, growth and technological wisdom. From where it has come? It has come based on, utilization of tools, techniques, ideas, background of, environmental engineering and scientific knowledge base. So accordingly, you have to also tackle with these many issues in the cyberspace with the help of scientific knowledge base, with the help of, this artificial intelligence knowledge base, with the help of this drone technology related knowledge base to bring out the new solutions for, these emerging problems in the society. I think, in the ending of this particular, this session, I also like to attract your attention towards the important, statement made by Oliver Wendell Holmes, Justice Holmes, where he says that, and I quote, "For the rational study of law, the black letter man, for the rational study of law, the black letter man may be the man of the present, but the man of the future is the man of statistics and the master of economics." So this statement of Justice Holmes is also giving us the impetus to think that the law or the legal research or the new solutions in the legal research, how exactly it is influencing the other disciplines from other disciplines. How statistics, how economy, or how economic analysis is also going to influence, very strongly our legal research in coming time. So from that particular perspective, you can think and you can, utilize this interdisciplinary approach from other disciplines knowledge base, other disciplines doctrines, other disciplines tools, other disciplines techniques, and you find out the new solutions, which I have just, given you certain important piecemeal ideas to provide you this, small orientation through this particular, this session in this faculty development program. There are many more issues. We can keep discussing, whole day on this particular aspect. But, at this juncture, I would, rest this particular talk here. And now entire house is open indeed for, questions, answer, and I will be very happy to provide those, answers to the different questions and queries.
Thank you so much for the informative and enlightening session, sir. So we have certain questions from our participants. Sir, would you like to proceed?
Yes, please go ahead.
Okay. So the first question is, sir, what is in your opinion are the hurdles in bringing, a comprehensive law on personal data protection? As we know that the PDP bill has been withdrawn after 4 years. So what is in your opinion are the hurdles?
Very good question. Very important question. And the entire world is tackling with this issue, not only India. Let me tell you again, I am remembering the wording of Justice Holmes again here, where he stated earlier that even minuscule numbers of the people and their say should also be facilitated in the lawmaking process. Means minority opinion of the, the society, that should also reflect in the lawmaking process. But that is one important version. But let me tell you, this is the entire, movement. It is going all over the world, not only in India. That successive government wants to regulate indeed this entire cyberspace, entire, this social media, entire this information and communication technology. I'm using the word successive government. You may be using the word, populist government or popular government. You take the example of Canada, you take the example of United States of America, you take the example of, many other European countries, you take the example of India, you take the example of other, countries, including China as well. This is the process and this is nothing but, one of the important strategy of the successive government, that they wants to regulate the social media, they wants to regulate, indeed this, entire cyberspace. But many important issues are also getting propped up. We have seen at the international level, general agreement of, this data protection. But I'm not talking about that general agreement of, this data protection. But recently, if you have come across, in the context of, our personal data protection bill, which had been introduced and then it had been taken back because Joint Parliamentary Committee had, pointed out many shortfall or many loopholes, how exactly it is not matching with the global standard of this, general agreement of data protection. But here, see, in the background of this particular, important, update or important happenings, you have to also understand that attempt from the side of different successive governments, including our India. Recently, India, in 2021, that regulation which has been brought into existence, that is intermediary guidelines and digital media ethics code rules 2021, which had been framed under Information Technology Act under section 79 of this particular, legislation. Now, this particular, this media ethics code rules, which is directly regulating, indeed, with the help of or through the government, entire this cyberspace or entire this social media. And that worry, that particular, apprehension that had also been shown, first of all, in all those 6-7 high courts, where, this LinkedIn, this WhatsApp, they had approached before this Kerala High Court, Delhi High Court, these other high courts of the country, saying that this particular, rules is totally against our human right, totally against with the free speech, totally against the, this media and, right to information, right to, have freedom of press, business. So it is totally against that particular, the constitutional rights. But more further, if you will see carefully, because I'm not going in the constitutional validity of this media ethics code rule 2021, I'm just, pointing out this particular, measures where government indeed, successive government indeed wants to regulate even, the individual rights or individual human rights. Because here question comes, with reference to again the privacy rights. Again, in encryption and decryption of the data by that internet service provider or that particular, social media, provider or that particular, this media news provider. Because by way of this kind of regulation, that is, it is not just like the thing that it is available in our country. It has been made available in other European countries as well on the similar background to regulate this social media, to regulate, this data, to regulate, personal information. But here the procedure which has been adopted, accepted, adopted, it is not based on, again, that reasonableness. It is not based on that necessity, proportionality. It is not also based on, the touchstone of, the constitutionality. Obviously, that particular aspect will be dealt when, the Supreme Court of India had clubbed those all important litigation in the context of, the social media and the privacy right and that personal data related issues. And I'm going to tell you, this comprehensive legislation related to personal data protection And I challenge, with my observation based on the statistics and evidence-based study, it is also not going to come, down the line more 4-5 years again. Because there is again apprehension all over the world, including India, that successive governments wants to regulate, and there is always negative and positive informed citizenry or decision making or the public opinion making with the help of social media. So successive government continuously wants to regulate that, but the issues are there with reference to data privacy, privacy rights, personal data protection. So obviously that has to be regulated with the the government and government machinery only, not with the help of these private players. So accordingly, oversight monitoring committee that had been proposed in this 2019 bill that would be worked out from the side of in comprehensive legislation in coming time. But again, there is tussle all over the world that individual human right and then successive governments, the regulatory measures, there is always tussle in between these two aspects. Because here continuously in social media, freedom of speech, freedom of information, personal right, human right, this particular individual right-based jurisprudence is conflicting with the governments or government policies, governments, we can say the thinking. But I'm sure the new ways will come, and expert committee is already working on this particular aspect. And we can also hope that a new robust legislation in coming time on this data protection and personal data protection and comprehensive legislation will come, which can be a real in reality, not just like taking away, or not just like any colorable legislation will happen, just like which has happened, I will say that, by way of this 2021 regulation or rule, based on this media ethics code rules.
Thank you so much, sir. I hope the concerned person has got the answer for his question. Now we are coming to the conclusion of this session. So I would like to extend my word of thanks for today. Now I would like to extend hearty word of thanks to the distinguished speakers for taking out their valuable time for this program. I would like to thank our principal, Dr. T.N. Prasad, sir, HOD Mr. Ashish Bhardwaj sir, and program coordinator Dr. Preeti Sharma ma'am for their continuous support and guidance in organizing this FDP. I would like to thank our technical team for the smooth flow of the session. We have been fortunate enough to be backed by a team of highly motivated and dedicated faculty members. So I would like to extend my vote of thanks to them. And lastly, I would like to thank all the participants for their gracious presence in the session. Now the feedback form link has been sent to you through the mail also, and it has also been shared on the chat box. I request all the participants to fill it and send it to us maximum by 9 a.m. tomorrow. And tomorrow being a holiday, I request you all to join the session on Monday, that is 22nd August, for the valedictory, and also a distinguished guest will be joining us that will be on board with us. Thank you so much. We'll be meeting on Monday.
Thank you so much.
Thank you, sir.
Dr. Preeti, Dr. Preeti, Dr. Swati, Dr. Ashish, all management of Asian Law College. Thank you so much for inviting me. And I'm always there for all participants as well. If they have any question, queries, my email ID and my other email ID is already provided, so they can get back to me. And thank you so much once again to all participants and all management.
Thank you, sir. Thank you so much.